Hey everyone, it's B with To Be Fruitful Training Group. All praises to the Most High. And today, before we get into it, just wanted to give a notice. This is for training and educational purposes only. This is for teaching and commenting in a classroom setting. Again, this is for training and educational purposes only. This does not constitute financial, tax, or legal advice. If you need any particular type of advice mentioned, please seek competent counsel. Do your own due diligence and fact check any information regardless of who presents it. And today we're going to be going over the Cestui Que Vie Act, Part 2. So we've gone over the acts, decrees, and the ordinances that have set the estate in motion as far as administration. But where does the estate really derive from? Well, it goes back all the way to Adam and Eve in the garden. The Creator entrusted unto Adam dominion over the earth, and the sons of Adam as heirs to this estate. So what do? So we're given this body or this vessel to experience this life. So the body or the corpus is property of the estate. So they take the heel and they prick the heel, and then take some of the blood of the child to bind the child to the name that the mother gives. And sometimes they do, footprints. They take, little footprints of the baby's souls and put it on a record to show that, your soul has been put on the document in more than one way. And the only way this happens is through the mother acting as an informant. Now, if you tried to go and ask most mothers, they would tell you that they had no intention of ever, intending to deliver the child to the state to birth or abandon. Because if you look in Anderson's Law Dictionary, 1889, it says birth, see abandon. So most of these mothers have never had an intention to do so, but whether knowingly or unknowingly, they deliver, via livery and season, livery and deed, via international law, the law of conveyancing, hands over delivery of the property, which is the child's body. So that's how the blood letting, the taking of the heel and taking of the blood and binding it using witchcraft, and essentially binding that child to the terms that they set forth according to the legal system. So in this instance, the mother is considered the settler of the trust. Now, she's just the settler of the trust, but that's not the highest office. The highest office is the office of the executor for the estate. And this is why once the child has inherited the beneficial title and the rights to the office, the child is able to then wind up the trust and go and reclaim the property of the estate, because the estate is where it would lawfully derive from. So what happens is whether the mother meant to or not, she acted as a trustee for the benefit of the state. So since one cannot benefit from their own wrong, it's considered unjust enrichment, because the mother owed a duty to the estate first. Equity regards as done what ought to have been done. It's a maxim of equity. So equity will convert her to a constructive trustee. And so now she has the duties firstly to the estate, and then to the state of. So she delivers all the legal title, and then it goes into the hands of the administrators. Now, these trustees or administrators, de Suntort, you have, the registrar of vital statistics, you have the United States trustees for the bankruptcy court, you have the bankruptcy court itself, the probate court, the IRS, Bureau of Fiscal Service, all the applicable authorized parties that handle the administrative affairs of the United States of America as it's presently known and being administered by the corporation. Because what people don't realize is that the federal government is essentially acting in a corporate capacity, the District of Columbia Act of 1871, and they're administering the public trust, which was nearly abandoned for the most part. Now, the trustees are considered the legal title holders. These legal title holders are the legal owners of the property. And then you have the child, which is the Cestui Que Vie under the trust, and they have the rights to reclaim the office of the executor. They're also the rightful receiver of the property, and in other terms, they are the tenant of the life estate. So the thing about this is that, none of this was really construed according to what ought to have been done. So that becomes the duty of the executor of the estate, which happens to be the child, the beneficial owner of the property. So this is kind of a general idea as far as what happens and how the trust was formed. So you have the estate, which funds and property, the body or corpus of the estate, was taken through the act of reversion, and that estate of inheritance was put into trust and then administered by administrators de sumptuary, trustees, the legal title owners, and those are the people claiming to hold the patents on all of the citizens. So this is where that came about as operation of law. So ultimately, the only one that really has the absolute right to go in and reclaim the estate is the one whose benefit the estate was created for, which happens to be the executor of the estate. And this is something also that ChatGPT understands. So what was asked of ChatGPT, so in the context of delivery of a child, the mother is the original settlor of the trust, the state is the trustee, and the beneficiary of the person created as a result of the transaction to represent the trust is the child itself, correct? And it came back and stated, in the context you're describing, it appears you're referring to a conceptual framework where a child's birth is likened to the creation of a trust. Here's how the roles might be defined in this analogy. Settlor. The mother who gives birth to the child would be seen as the original settlor because she initiates the process that leads to the child's existence and potential legal arrangements, such as birth certificates, social security numbers, etc. The trustee. The state or governmental entities that handle the administrative aspects of a child's identity and legal status. Example given, issuing birth certificates, providing social security numbers, overseeing certain welfare benefits, could be seen as trustees. They manage and oversee the legal and administrative framework that supports the child identity and legal status. 3. Beneficiary. The child is the beneficiary, as they are the one who ultimately benefits from the trust-like arrangement set up to manage their identity, legal status, and any associated rights or benefits. This analogy simplifies a complex legal and social framework into the structure of a trust. The mother, settlor, initiates the creation of a child's legal identity. The state, trustee, administers and manages this legal identity. The child, beneficiary, receives the benefits and legal recognition resulting from this arrangement. It is important to note that this analogy might oversimplify the legal realities and might not be a perfect fit for all situations. Legal definitions and roles in actual trusts and estates are specific and governed by law, whereas this analogy uses trust terminology to describe the legal and administrative processes surrounding the birth and identity of a child. So even ChatGPT is saying they used an administrative process to create this, and they control the terms that they create. So what this is stating is, in trust terminology, it is a trust. When you use their terminology, it's something else. It becomes a usufruct. which in essence is essentially a trust. But clearly this is something even ChatGPT understands, because if you give ChatGPT a wrong answer, it'll tell you too. And conversing with ChatGPT further, it said, continuing in this particular context, showing that the name or the identity is the proof or the representation of the child, thereby establishing the trust. The trust had to come from a specific estate for this case, so this estate did not authorize the delivery of the child by the mother. So in that context, could the father, as guardian of the child's estate, go then and reclaim the identity or the trust's property that was taken without authorization from the executor and guardian of the estate, the father of the child? ChatGPT answered and said, in this context, where the identity or the name of the child is considered proof of the child's existence and thereby establishes a trust, several legal principles and roles come into play. To summarize, child's identity, considered the trust property, mother, seen as the original settlor, father, acting as the guardian and potentially guardian of the child's estate, and the state, acting as the trustee, managing the administrative aspects of the child's identity. Given this context, if the estate, the trust, did not authorize the delivery of the child by the mother, and the father is the guardian of the child's estate, then the father could potentially have grounds to reclaim the identity or trust property if it was taken without proper authorization. Here are some steps and considerations in such a scenario. Legal standing. The father, as the guardian of the child's estate, would need to establish his legal standing and authority to act on behalf of the child's estate. This typically involves court appointments or legal documents granting him guardianship. Unauthorized actions. The claim that the delivery of the child and subsequent actions related to the child's identity were unauthorized would need to be substantiated. This could involve proving that the mother or other parties acted without legal consent or overstepped their authority. Reclaiming trust property. To reclaim the child's identity or trust property, the father would likely need to take legal action. This can include filing a petition. Father might file a petition in probate or family court to address the unauthorized actions and seek to reclaim the child's identity or any associated benefits. Proving guardianship rights. The father would need to prove his rights as the guardian of the child's estate and his authority to manage and protect the child's interests. Restitution or compensation. Depending on the legal framework, the father might seek restitution or compensation for any losses or damages incurred due to the unauthorized actions. 4. Court orders. If the court finds in favor of the father, it could issue orders to correct the situation. This might involve reestablishing the child's identity, amending records, or taking other corrective actions to restore the trust property to its proper status under the father's guardianship. Alright, so it's got some other considerations, saying that there's specifics via state law, gather all the relevant records, all the proof that you have, prima facie evidence, and it advises for legal counsel, although attorneys and lawyers can only represent the interests of the state, so do with that what you will. Ultimately, the father's ability to reclaim the child's identity or trust property would depend on demonstrating his legal authority, the unauthorized nature of the actions taken, and the legal remedies available within the jurisdiction. For this particular circumstance, upon having done due diligence, there are no adequate remedies at law. So in equitable terms, what are the applicable equitable remedies or relief that would be applied to this situation to achieve the desired result and reclaim the trust property, the minor's identity, from the administrative control of the state? In a situation where legal remedies are inadequate, equitable remedies can be sought to address the unauthorized actions and reclaim the minor's identity from the administrative control of the state. Here are the primary equitable remedies that may be applicable. An injunction. An injunction is a court order requiring a party to do or refrain from doing specific acts. In this case, an injunction could be sought to prevent the state or any other party from continuing to control the minor's identity, compel the state to transfer administrative control of the minor's identity to the guardian, the father. Declaratory relief. A declaratory judgment is a legal determination of the party's rights without ordering any specific action or awarding damages. The father could seek a declaratory judgment to establish his rights as the guardian of the minor's estate, confirm that the minor's identity was taken without proper authorization, and declare that the state's control over the minor's identity is invalid. 3. Constructive trust. A constructive trust is an equitable remedy where the court declares that a party holding property is doing so as trustee for the benefit of another. This remedy could be used to recognize that the state holds the minor's identity in trust for the benefit of the minor and the guardian, require the state to transfer control of the minor's identity to the father as rightful guardian and beneficiary, and restitution. Restitution involves restoring the plaintiff to the position they were in before the wrong occurred. In this context, restitution could include reclaiming any benefits or rights associated with the minor's identity that were taken by the state, and returning an administrative control and any related documents or records to the guardian. Specific performance. The remedy compels a party to perform a specific act, often used when monetary damages are inadequate. Specific performance could be sought to require the state to take specific actions to correct the records and transfer control of the minor's identity to the guardian. Steps to pursue equitable remedies. File a lawsuit in equity court. Begin by filing a lawsuit in a court that has the jurisdiction to grant equitable remedies. This might be probate court, family court, or a court of equity, depending on your jurisdiction. Present evidence. Provide thorough documentation and evidence to support your claims. Everything that you state in court has to be proven. Proof of guardianship and your legal standing as a guardian. Evidence of the unauthorized actions taken by the state or other parties. Demonstrations of how legal remedies are inadequate and why equitable relief is necessary. So it says seek temporary relief. If needed, you can get a temporary restraining order or a preliminary injunction while cases are pending. You can make an argument for equitable remedies. You have to be able to clearly articulate that. And it's, again, advising legal counsel. They can only represent the interests of the state, so again, do your own due diligence and decide what's best for your situation. Equitable principles that are involved. Clean hands doctrine. Clean hands doctrine is essential to all of this. Everything that you do in equity, especially when you're looking to obtain any type of relief for that specific matter, you have to have clean hands. That's why you've got to operate on a high level, doing this the proper way. So it says, ensure that you have acted ethically and fairly in the matter, as courts will not grant equitable relief to parties with unclean hands. Balancing of hardships. Argue that the balance of hardships favors granting equitable relief to prevent further harm to the minor's estate and identity. By seeking these equitable remedies, the goal to restore the control of the minor's identity to the rightful guardian and correct any unauthorized actions taken by the state or other parties. So let's just go ahead and say that you've made, all of those particular actions in state court, and you've gotten beyond that jurisdiction. What is left at that point? And it says, if state courts disclaim jurisdiction over a minor's estate and the federal courts need to become involved, there are specific scenarios and federal court types that might come into play. District court, bankruptcy court, court of claims. So it says identify. So I came back and said, so seeing as the estate has been bankrupt, as the United States has had no lawful money in circulation since 1933 via House Joint Resolution 192, Public Law 73-10, and Richard Nixon's suspension of the convertibility of the dollar to gold in 1971, then would bankruptcy be the proper venue, seeing as this involves issues of bankruptcy? If the minor's estate is in bankruptcy, and given the context that the estate's financial issues are intertwined with broader legal and monetary considerations, the following aspects should be considered. Bankruptcy court jurisdiction. bankruptcy matters are generally handled by federal bankruptcy courts. If the minor's estate is bankrupt, and there are unresolved issues or claims involving the estate's debts, the bankruptcy court would typically have jurisdiction to handle these matters. Bankruptcy filing. For the bankruptcy court to get involved, a formal bankruptcy petition must be filed. This petition could be filed by a representative of the estate, such as a guardian or legal representative. Legal context. House Joint Resolution 192, 1933. This resolution suspended the gold standard and allowed for the discharge of certain debts in paper currency. It is a historical context for understanding U.S. monetary policy, but doesn't typically affect the procedural aspects of modern bankruptcy cases directly. And ChatGPT states this because everything is on a case-by-case basis. If you do not claim a specific standing or position, it may not apply to you. Richard Nixon's suspension, 1971. Nixon's actions ended the convertibility of the dollar to gold, shifting the U.S. to a fiat currency system. This has implications for monetary policy, but also doesn't directly change how bankruptcy courts handle cases. Relevance to bankruptcy. Despite historical changes in monetary policy, the bankruptcy system remains a viable and structured legal avenue for resolving debt and financial issues. The federal bankruptcy court can manage the administration of the bankrupt estate, including dealing with creditors and distributing any remaining assets according to bankruptcy laws. Practical steps. File a bankruptcy petition. If the estate is not already in bankruptcy, a representative should file a bankruptcy petition in the federal bankruptcy court. This starts the process of addressing debts and financial claims. Handle administrative matters. The bankruptcy court will oversee the estate's assets, debts, and liabilities and will provide for an orderly resolution. Consultation with legal counsel. And they just want you to, again, sending you back to the same people, the lawyers and bar attorneys. In summary, if bankruptcy is relevant to the estate's financial status, the bankruptcy court would be the appropriate federal venue to address and manage these issues. Historical monetary policy changes do not typically alter the fundamental process of bankruptcy courts in handling estate matters. So basically, it continues on to state that, the gold and silver has been the only thing that has been the lawful money within the original organic written constitution for the United States of America and its original context and interpretation. So it states here, constitutional basis and historical context. The original Constitution, the U.S. Constitution as originally written, authorized the use of gold and silver as a legal tender. Article 1, Section 10 of the Constitution states that no state shall make anything but gold and silver coin a tender in payment of debts. This was a reflection of the economic understanding and practices of the late 18th and the early 19th centuries. And it never really went out of effect. Historical developments. Gold standard. The U.S. operated under a gold standard system at various points in its history, where the value of currency was directly tied to a specific amount of gold. Modern monetary policy. Fiat currency. The modern U.S. monetary system is based on fiat currency, which means the value of money is not backed by physical commodities like gold and silver, but is instead based on the government's declaration and trust in the currency. This system allows for greater flexibility in monetary policy and economic management. So, this is kind of how this thing came about. So something to be aware of. And since this is on a case-by-case basis, if this does apply to you, make sure to include as much evidence as you can, including prima facie, at first glance or at first face evidence, and make sure that you clearly shift the burden of proof to the trustees. Make sure you have all your orders together, all of the applicable documentation, just make sure it's your case is well presented and that you have everything, if you pursue this avenue. Again, this is not legal advice. This is not financial advice. This is not tax advice. If you need any particular type of advice aforementioned, please seek competent counsel. But again, hopefully this kind of gives a better understanding of what's going on and how it came about. If you have any questions, feel free to, leave a comment. And yeah. So, and further, something else that we're going to be looking at is involved with the delivery is called livery in season. Now, this is an archaic term that to this day still has effects. So this is out of the Washington Post, and it says real estate law is to a large extent quite archaic. If one looks to the origin of a lot of our real estate doctrines, they can be found in the English feudal system. In those days, for example, in order for a piece of property to be legally transferred prior to the 17th century, the typical form of conveyance was called the feoffment with livery of season. I doubt that most lawyers today understand this concept, although we all remember these terms from our first property law course. The seller would formally give or deliver the season to the buyer in the presence of witnesses from the neighborhood. In order to complete the transaction, a ceremonial act took place, whereby the seller actually gave the buyer a twig, branch, or piece of the ground as a symbol of the delivery. In return, the seller received, quote, a peppercorn to assure valuable consideration for the transaction. Another Old English concept was the doctrine of merger. This doctrine held that all prior negotiations entered into between the buyer and the seller merged into the deed when it was accepted by the buyer. That's talking about a trust merger of legal and equitable titles, whereby the beneficial owner receives the legal title and the conveyance is perfected and the trust purpose has been fulfilled. In other words, the buyer, by taking the twig to the property, in this case, the deed, indicated his satisfaction with the entire transaction, and thus all previous negotiations, including the sales contract, were merged into that deed. In simple terms, the doctrine of merger stood for the proposition that once a buyer took the deed, he could not sue the seller for breach of contract. And further quoting Charlton's Web, we have livery of season. Livery of season is an archaic legal conveyancing ceremony formerly practiced in feudal England and in other countries following English common law, used to convey holdings in property. The term livery is closely related to, if not synonymous with, delivery, used in some jurisdictions in contract law or related law of deeds. The oldest form of common law provided that a valid conveyance of a feudal tenure in land required physical transfer by the transferor to the transferee in the presence of witnesses of a piece of the ground itself, in the literal sense of a hand-to-hand passing of an amount of soil, a twig, key to a building on that land, or other token. Varieties. Livery of season could refer to either livery and deed, whereby the parties met together on the land, and the transferor symbolically delivered possession of the land by handing over a twig or a clump of earth to the recipient, and livery in law, whereby the parties went within the site of the land, and the transferor declared to the recipient that possession was being given, followed by the recipient entering into the land. The symbol of livery for a house was the door's ring or hasp, for mills, the clap and hopper, for a church, a psalm book and keys, and so on. So this is where you get the planting of a tree when you have inaugurations and other types of international meetings. So it says the turf and twig ceremony dates from the feudal era, but was used regularly in earlier colonial America, allowing the English and Scottish, after 1707 termed the British, by virtue of their monarchs' claims to take sovereign possession over unclaimed lands. The process has taken several forms over the centuries. So this is the particular type of conveyancing that delivery has, especially in relation to even the delivery of a child, because there's more than one definition of a child. So, since the bodies of slaves, because of the status of civil death, um, the body is taken from dust and returns to dust. So, the bodies of slaves are treated as according to the land. So, the lands, tenements, and hereditaments that were conveyed and held in trust, alienated from the estate. This is why we have these different symbols or these names, the intellectual property, the estate, there to symbolize, via quantum entanglement, the actual thing that it represents, to signify the passing via the little thing of the larger thing. This is why you have the tree planting ceremony that all these presidents do and things like that. And as far as the appointment to the office of executor, I would go ahead and take a look at the court of record, its original meaning and how it's defined. This is something that, very clearly has implications. What they don't like to tell people is that you have the power, because it's your name and your property. You have the right of self-determination. So don't let these people take your own identity and tell you what you are. If you know what you are, stand on what you know. Only you are able to determine who and what you are and declare that to the public. So yeah, don't let somebody else tell you who you are. Decide that for yourself. If you need any additional resources or any reference material, or you're curious about the other services that it's provided by To Be Fruitful Training Group, leave a comment, send us a DM, check out our website. Any donations over $50 will receive a link to the private library. And any other questions, again, feel free to reach out. Do your own due diligence. Again, all of this is different than what most people's normal paradigm really allows them to be able to comprehend. That's why you get a lot of cognitive dissonance in the public, because the public has derivated from the truth for quite a long time, and the truth is always stranger than fiction. So yeah, so hopefully this was helpful. We'll see you on the next one. Thank y'all.